All right, everyone, welcome back to the Regent Law Podcast for another constitutional conversations where we make constitutional law approachable. And I try to say the word constitutional correctly. So we're off to a
Hey,
great
Pat.
start. Today we're doing
No, no.
another case update. What's the case, Christian?
Yeah, doing Mahmoud versus Taylor.
Okay.
Um, Another case. I feel like all three of the cases we're doing updates on in the next few days are dealing with parental stuff.
Okay.
Parents, they're really important cases for parents. So if you're a parent, I would tune into these because these actually have actual impact on how you parent your children. And so this one's dealing with religious parents. So, and do they have a say in what their children learn in public schools? That's kind of the broad idea of what's
Okay.
going on in this
Mahmoud
case.
versus Taylor. The Supreme Court opinion just came out. Who is Mahmoud?
Yeah, so Mahmoud, this is a family. This is a Muslim family. This takes place in Montgomery County,
Okay.
Maryland, and in the school district there. And so the Mahmouds are a family, but they're not the only ones. There's also a couple of other families, very diverse religious backgrounds of these families. Some are Ukrainian Orthodox, some are Catholic, some, as I said, are Muslim. And these are parents that don't want their children to participate in this certain curriculum that the school district implements.
Okay.
Well, let me tell you about the curriculum because it's pretty interesting. So it is as the in quotes what the Supreme Court called it is LGBTQ plus inclusive curriculum.
Okay.
So this is curriculum that is used in preschool all the way up through fifth grade, and it's in the language arts area. And they basically use LGBTQ themes to teach language arts. So, to put it in perspective, in the pre K, which my son is in pre K right now, we are desperately trying to learn how to write our name. We just struggle with the R's, Pat. We struggle with the R's. And so, there, though, that's something that your language arts would teach even in pre K. They have a LGBTQ themed book to teach the ABCs, and the book is called Pride Puppy,
Okay.
and it's about a puppy that goes to a pride parade and learns the ABCs.
Okay.
And I've looked at the book, and so that's what it is. And they have other curriculum and books and things that are used as kids get older, up through fifth
So
grade.
is this
And
this is a public
yeah,
school?
public
So
school,
this
yeah,
is
public.
four families that join together are represented. That's the Mahmoud versus Taylor.
Yeah,
So this is 4 or 5 families of different religious faiths saying, what are they exactly? What are
yeah.
they fighting for? We don't want this in the schools.
No,
Okay.
that's what's kind of interesting here. It's not that they don't want their this to be taught or that it should never be in the curriculum. What happened, and this is what makes the case kind of interesting. The school district had a notice and opt out policy, which essentially, what am I meaning? Hey, by the way, we're going to be using this curriculum tomorrow. If you don't want your children to participate in it, they can leave the room during it. Think back, we talked about in a previous episode, think back to sexual education,
Totally.
right? Yeah, okay, I mean, and I think back on this, and they always told us beforehand. Now I know why, right? Because there were some students that were going to opt out, and we all had probably people in our classes that just left and went to the library or to a different classroom because they didn't want to participate
Or maybe
in the
their
sexual.
parents even kept them home that day, depending on how the
Yeah,
school did notice.
it's however the school sets up the policy of how you can opt out. And so that's what happened here. They gave notice, we're going to use this curriculum and you can leave during it. And so they had this policy and everything was fine and no one was complaining. But then abruptly, they got rid of the policy,
Okay.
got rid of notice, opt out. And they cited essentially, if you put it in a nutshell, administrative ease. That it's an administrative nightmare trying to do this.
This isn't efficient. This is, in the school's opinion, maybe they can't afford the resources. It's a waste of time or whatever.
It disrupts the course of learning, whatever you want to say. Let's just call it administrative ease, and that's what they cited.
Okay.
So the parents, they're not saying that you shouldn't have this curriculum. They're saying we should have notice of it being taught and the ability to opt out. Since you've taken that away from us, We think this is burdening our religious exercise. So they brought a free exercise claim
Okay.
under.
So what's the right? What's the constitutional right that they were?
Yeah, so it's the First Amendment, and the First Amendment says that the government cannot burden the free exercise of your religion, essentially your religious activity. The government can't tell you what you can and can't do in your religious life, is what they're saying. And they're saying by you not giving us the opt out, by you mandating that my child
Oh,
participate in this type of learning, you are burdening my religious
okay.
exercise as a parent.
So what did
So that's
so
their claim.
so what did the court decide?
Yeah, so the court sided with the parents. It's an interesting opinion. The court said this does burden the free exercise of your religion, but it was interesting how they got there.
Okay.
And let me just kind of break down why that's important. There's an old Supreme Court case from the 1970s. We're always going to the old ones.
Click,
This is not
click.
as old as the one. Yeah, click, click. 1970s opinion. Here we go. Wisconsin versus Yoder. All right. Still good law. But we thought it didn't have much meaning anymore until this opinion. So let me explain. Yoder's about Amish parents that mandatory K through 12 school, right? You had to go to school, and the Amish parents said, actually, we have a religious objection to our children going to school after eighth grade.
Okay.
Okay, compulsory education violates our religious exercise. And the Supreme Court in the 1970s said, yes, you have a right to develop your child in religious tenets. This violates that. Therefore, there is a free exercise problem. All right, you got that opinion in the 70s. And it said, if there is a burdening of your religion, and it comes up all the time, Pat, strict scrutiny. Okay. Right. So strict scrutiny, we've talked about in prior episodes, compelling government interest, narrowly tailored. If you don't meet those two, unconstitutional. And so that's what the test was for a long time. If there's a free exercise problem, we look at strict scrutiny. And then there was a case in the early 1990s that a lot of religious people and conservative scholars do not like, and it's called Employment Division versus Smith.
Yeah.
And it's about a guy in Oregon that wanted to smoke peyote, and it's about unemployment benefits and all this stuff. But just know that Justice Scalia authored the opinion, and he says, listen, if there's a law that's neutral, it's not singling out anyone for their religious beliefs, and it's generally applicable, it's not just singling out religious individuals, then if it incidentally burdens your religious practice, so be it. So it totally changed, the religion clause's jurisprudence, meaning just how the cases are adjudicated, right? No longer was, if you're burdening religious exercise, you have to undergo really high level of scrutiny, strict scrutiny. It was then just, if it's a neutral law and if it applies to everyone, then it's okay. And we kind of thought that this Yoder case, the Amish parents case, just didn't mean anything anymore. And I think a lot of people thought, well, that's going to apply here. This seems to be a neutral, policy that's generally applied. So too bad, so sad, parents. And the Supreme Court actually, and Justice Alito said no. When we have a case that is on all fours, similar to Yoder, Yoder applies. And the court basically said, and this is kind of their language, that if you substantially burden the religious development of your child, of someone's child, that is a religious burden. And here, this was hindering that development by requiring them to learn materials that, as the court called it, were hostile to these parents' religious practices. The thing that's kind of interesting is the court made clear this is not like a history class, right, where you're learning about LGBTQ history, which many history books deal with. This was a curriculum that celebrated certain ideological views,
Right.
and actually said if you have other views that they should be rejected. And so the court said that is a burden on these parents'
Right.
religious exercise. So it's a big case. It's a really big case.
So how's this going to affect culture, society, Americans' lives?
I mean, Pat, this one's, I can't make it, put it any more clearly, this is a huge, huge case for parents. I mean, you and I, we're grappling with it right now. Private school, public
Yep.
school, homeschool. What do you do with your kids? What this opinion says is that if you have a child in a public school and there is some type of curriculum that is used that you find objectionable for religious reasons, you should be able to get out of your child learning that. That's really, that's broader than actually the holding, but that is the implication of it. If you have a religious objection to some type of curriculum in a public school, no longer is it, you just have to deal with it. You're in public school. No, you might have an opportunity to bring, ask for an opt out and bring a lawsuit saying this is a free exercise problem. It's going to set up a lot of cases in the future for parents who are worried about the religious development of their children. And if the government is burdening that religious development, we are now going to say, see Mahmoud versus Taylor, that has to undergo strict scrutiny. And this has just not been something we've had for the
Wow.
past 30, 35 years. It's a really, really big case and a big win for parents.
Wow. That's awesome. Thanks for bringing it down to normal plain speak as much as possible. As a parent who is navigate 3 kids in elementary, middle, and almost high school, in a normal city here in Virginia Beach, thinking about what do you do based on costs, and does this school align with my beliefs, and is that even a main concern of mine, or am I just looking at past academic? There's so many questions. This is a really fascinating case. So thanks for that. And
Yeah, absolutely.
anything else you want to say about Mahmoud?
Well, no, we don't want to brag, but I mean, I am here at HQ. This is the Robertson Center for Constitutional Law I'm sitting at. We did write a brief in this case, so we were a part of the team with Mahmoud, and so we're excited with all these cases that we agree with, but we were especially excited for this one because we were part of the group that helped here. We wrote a amicus brief in this case, and we highlighted some fantastic scholarship from some of our professors, Professor Walton and Professor DeGroff. And yeah, we're really proud of that and that we were part of the winning side here. So, and again, as we always say, it's not just myself and the other professors. It was our team of interns that helped us write this brief. So, as a team effort, we were able to contribute in this win for parents in the Supreme Court.
Super cool. So, as a reminder, if you're a prospective student considering law schools and the area of constitutional law is an area of passion, there's opportunities at Regent Law School potentially to be a part of the Robertson Center for Constitutional Law, and maybe you could be a student intern that could participate in these cases as well. All right, thanks, Christian. As
Yeah.
always, to learn more about Regent Law School or the Robertson Center for Constitutional Law, check the links below in the bio. This was a great case update, and we'll be back with another case update soon. Thanks.
Have a good one.